Registration Act. Frequently asked questions on Registration Act. Q. 1. Write a short note on commencement of Indian Registration Act and also discuss the scope and objects of Indian Registration Act. Ans. Prior to the enactment of the Indian Registration Act, 1903, the laws relating to the registration of documents were scattered about in several enactments. Therefore, this Act was passed to consolidate all these laws and to incorporate them in the Act. Thus, the law in respect to registration of documents was made uniform. The Indian Registration Act, 1908, came into force on the first day of January, 1909. As provided in Section 1, 2, it extends to the whole of India, except the state of Jammu and Kashmir, with proviso that the state government may exclude any districts or tracts of country from its operation. The object of the legislature in passing this act is to give certainty to titles and to prevent the operation of fraudulent and secret transactions by which a man's title in the property which he has acquired may be defeated. Purpose of Registration Act. The preamble of the Indian Registration Act, 1908, lays down an act to consolidate the enactments relating to the legislation of documents. Whereas it is expedient to consolidate the enactments relating to registration of documents, so one of the purpose of the Act is provide complete and codified law on the subject of registration of documents. Another important purpose of law of registration is to inform people, who may deal with property, as to nature and extent of the rights which persons may have, affecting that property. Another important object is to give legal sanctity to certain classes of documents or to perpetuate documents, presence of which will be an evidence of the fact that certain transaction has taken place in respect of a movable or movable property or other change of legal status. Scope of the Act. Indian Registration Act is primarily concerned with documents and not with transaction. It is only concerned with the fact that all those documents as mentioned in Section 17 of the Act must be registered so that legal importance may be attached with transactions. Q. To define and explain following. I. Addition. E. Immovable property. E. Lease. IV. Moveable property. Ans. I. Addition. Section 2, 1, of Indian Registration Act says, addition means the place of residence and the profession, trade, rank and title, if any, of a person described, and indicates of an Indian. His caste, if any, and his father's name, or where he is usually described as the son of his mother, then his mother's name. So, addition means all those informations which, apart from the name of a person, give much deeper or detailed identity of him for the purpose of Act. E. Immovable property. Section 2, 6, of Indian Registration Act says, immovable property includes land, buildings, hereditary allowance, rights to ways, lights, ferries, fisheries or any other benefit to arise out of land and things attached to the earth but not standing timber, growing crops or grass. Definition of term immovable property, as given in Section 3 of Transfer of Property Act is not exhaustive, it simply say, a movable property does not include standing timber, growing crops or grass. Similarly, definition of term is given under Section 2(26) of General Clause Act is not comprehensive. 1. It states, a movable property shall include land, benefits to arise out of land and things attached to the earth or permanently fastened to anything attached to the earth. So on joint reading of above said definitions, it is clear that a movable property does not include standing timber, growing crops or grass, but it includes I. Land, E. Building, E. Hereditary allowance, IV. Rights to ways, V. Rights to light, V. Right to ferries, V. Right to fisheries, V. Benefits to arise out of land, X. Things attached to earth, E. Lease. Section 2(7) of Indian Registration Act says, lease includes a counterpart, qabliyat, an undertaking to cultivate or occupy and an agreement to cultivate or occupy and an agreement to lease. Definition of lease, U.S. 2(7) of Act is not exhaustive. Section 105 of Transfer of Property Act says, a lease of a movable property is a transfer of a right to enjoy such property, made for a certain time, express or implied or in perpetuity, in consideration of a price paid or promised or of money, a share of crops, service or any other thing of value, to be tendered periodically or on specified occasions to the transferor by the transferee, who accepts the transfer on such terms. So lease in simple words means transfer of right to enjoy of a property for specified period and for money or money's worth. Movable property according to Section 2(9). Movable property includes standing timber, growing crops and grass, fruit upon and juice in trees and the property of every other description, except a movable property. Q3. Discuss briefly the provisions of Indian Registration Act regarding establishment of the Registration Department. Ans. Inspector General of Registration. Section 3 of the Indian Registration Act, 1908, provides that the state government is empowered to appoint an Inspector General of Registration for the territories subject to it, provided that the state government may, instead of making such appointment, direct that all or any of the powers and duties hereinafter conferred and imposed upon the Inspector General shall be exercised and performed by such officer or officers, and within such local limits as the state government appoint in this behalf. The Inspector General of Registration so appointed is regarded the head of Registration Department and has full control over its establishment. The state government is also empowered to form districts and sub-districts for the purpose of this Act and to appoint registrars and sub-registrars for the districts and the sub-districts so formed. Office of the Registrar and Sub-Registrar. 1. The state government shall establish in every district an office to be styled the Office of the Registrar and in every sub-district an office or office to be styled the Office of the Sub-Registrar or the Office of the Joint Sub-Registrar. 2. The state government may amalgamate with any office of a registrar any office of a sub-registrar subordinate to such registrar and may authorize any sub-registrar whose office has been so amalgamated to exercise and perform, in addition to his own powers and duties, all or any of the powers and duties of the registrar to whom he is subordinate, provided that no such authorization shall enable a sub-registrar to hear an appeal against an order passed by himself under this Act. Sections 5 to 7. It may also appoint officers, to be called Inspector of Registration Officers, and may prescribe the duties of such officers. Section 8. Under Section 10, in the absence of registrar or vacancy in his office, or in default of such appointment, the district judge shall be the registrar. Under Section 11, in the absence of registrar on duty in his district, any sub-registrar or other person may be appointed by him to perform his duties except those mentioned in Sections 68 and 72. Under Section 12, in the absence of the sub-registrar, any person appointed by the registrar shall be the registrar. Under Section 13, it is provided that the appointment made under Section 10 to 12 shall be reported, either specially or generally, to the state government by the Inspector General of Registration. Q. 4. What are the documents of which registration is compulsory or optional under the Indian Registration Act? Ans. Documents of which registration is compulsory, under Section 17(1) of the Indian Registration Act, the following documents are required to be registered compulsorily. If the property to which they relate is situate in district in which, and if they have been executed on or after the date on which Act No. 16 of 1864, or the Indian Registration Act, 1871, or the Indian Registration Act, 1877, or this Act came or comes into force, namely a. Instruments of gifts of immovable property. b. Other non-testamentary instruments which purport or operate to create, declare, assign, limit or extinguish, whether in present or in future, any right, title or interest, whether vested or contingent, of the value of 100 rupees and upwards to or in immovable property. c. Non-testamentary instruments which acknowledge the receipt or payment of any consideration on account of the creation, declaration, assignment, limitation or extinction of any such right, title or interest. d. Leases of immovable property from year to year or for any term exceeding 1 year, or reserving yearly rent. a. Non-testamentary instruments transferring or assigning any decree or order of a court or any award when such decree or order or award purports or operates to create, declare, assign, limit or extinguish, whether in present or in future, any right, title or interest, whether vested or contingent, of the value of 100 rupees and upwards, to or in immovable property, and f. Authorities to adopt a son, executed after the 1st of January 1872 and not conferred by will, Section 17(3). g. Any other instrument required by any law for the time being in force to be registered, provided that the state government may, by order published in the Official Gazette, exempt from the operation of this subsection any leases executed in any district, or part of a district, the terms granted by which do not exceed 5 years, and the annual rents reserves by which do not exceed 50 rupees. documents of which registration is optional. Section 18 of the Registration Act provides as follows. Any of the following documents may be registered under this Act, namely: a. Instruments, other than instruments of gift and wills, which purport or operate to create, declare, assign, limit or extinguish, whether in present or in future, any right, title, or interest, whether vested or contingent, of a value less than 100 rupees to or in immovable property. B. Instruments acknowledging the receipt or payment of any consideration on account of the creation, declaration, assignment, limitation or extinction of any such right, title or interest. C. Leases of immovable property for any terms not exceeding 1 year, and leases exempted under Section 17. D. Instruments transferring or assigning any decree or order of a court or any award when such decree or order or award purports to or operates to create, declare, assign, limit, extinguish, whether in present or in future, any right, title or interest, whether vested or contingent, of a value less than 100 rupees, to or in immovable property. A. Instruments, other than wills, which purport or operate to create, declare, assign, limit or extinguish any right, title or interest to or in movable property. F. Wills, and G. All other documents not required by Section 17 to be registered. Section 18. Q. 5 A. Muslim executes a deed of gift of his property to B, but the gift is not accompanied by delivery of possession. A. Subsequently executes a deed of gift of the same property to C, and the gift is accompanied by delivery of possession. Both the deeds are registered. Is B entitled to the property? Discuss the relevant provisions of Registration Act. Ans. Under Muslim law, a valid gift involves following steps. I. A declaration of gift by donor. E. Acceptance of gift expressly or impliedly by or on behalf of donee. E. Delivery of subject matter of gift from donor to donee. In Abdul Manan vs. Muhammad, Murad Ali and other 1999 family law cases 108, Patna, it was observed that it is necessary for the validity of a gift under Muslim law that a. There shall be declaration of gift by donor, b. Acceptance of gift by donee, c. Delivery of possession of property gifted by donor to donee. So delivery of subject matter of gift from donor to donee is essential for the validity of a gift under Muslim law. Section 17, 1, of Indian Registration Act provides that instrument of gift of immovable property is required to be registered compulsorily in Section 123 of Transfer of Property Act provides that for the purpose of making a gift of immovable property, the transfer must be effected by a registered instrument signed by or on behalf of the donor and attested by at least 2 witnesses. But Section 129 of Transfer of Property Act expressly excludes the application of Section 123 of Act in the case of Mohammedan gift. So a gift by a Muslim must at least fulfill all essential conditions as to gift under Muslim law, and it is not necessary for a Mohammedan to execute a registered instrument for transferring a movable property by way of gift is required under Section 123 of Transfer of Property Act. In such a case it is sufficient to conform to the rule of Muslim law. A gift by a Muslim which is accompanied by delivery of possession is valid nonetheless. The gift deed is not executed and registered. Registration of a gift deed will not cure the defect if the gift is invalid under Muslim law by reason of not delivering the possession of subject matter of gift to donee. In the case in hand, a Muslim though executed a registered gift deed to B, but gift is not accompanied by delivery of possession of subject matter of gift. Therefore gift to B is not valid under Muslim law, whereas registered gift deed along with delivery of possession of property gifted to C is valid and complete. Registered gift deed in favor of B will not in any way help B. Q. 6A and B divided certain joint properties between themselves on 28 January 1973. On 16 December 1975, B handed over a declaration to A, in these words: "You have constructed shops and are constructing houses on property appertaining to your share in the same. I have no interest of any kind." Whether the above declaration requires a registration? Ans. Section 17, 1, b, Indian Registration Act lays down that all non-testamentary instruments which purport or operate to create, declare, assign, limit or extinguish, whether in present or in future, any right, title or interest whether vested or contingent of the value of 100 rupees and upwards, to or in a movable property are compulsorily registerable. So in order that the instrument may come within the purview of Section 17, 1, b, it must itself create, declare, assign or limit or extinguish some right, title or interest. The right or interest which is to be created must be by the document itself. To be compulsory registerable under Section 17, 1, b, of the Act, the non-testamentary instrument must by reason of the declaration of some right, title or interest to or in a movable property effect a definite change in legal relation to the property by an express of will. In Sakharam Krishnji vs Madan Krishnji, ILR 5 Bom. 232, it was held that a writing which merely recites that there has been, in past, a family partition is not a declaration of will. A document which acknowledges the past partition is not compulsorily registerable. Facts of the case in hand were drawn from the case of Sakha Ram Krishnji, Supra, in which West J, referring to letter admitting that a partition had taken place, has observed, "It does in one sense declares a right. That is, the existence of the right is directly or indirectly stated, but it is not the declaration of will by which right is constituted," and held that this was not the sense in which the word "declare" was used in Registration Act. In the case in hand, partition had already taken place between A and B. The declaration handed over on 16 December 75 by B to A is merely an acknowledgement of the fact that the right to the property on which A has constructed shops and is constructing houses vested in A. This declaration does not create, declare, extinguish etc. any right to or in a movable property. Therefore it does not require registration under Section 17(1)(b) of Act. Q. 7. Does the family arrangement, the terms of which are reduced into the writing, require compulsory registration, and whether a memorandum prepared after family arrangements had already been made for the purpose of record also require compulsory registration? Ans. Family arrangement is an agreement between all family members, whereby an arrangement of all family property is arrived at and demarcation is made about the share of each member of a family so as to avoid any dispute which may arise regarding share of any member of family for property of the family. It is to be remembered that family arrangement may be of any type, but when decides about rights of each member for its properties, then certainly defines and gives declaration of rights of members in the family. Question of registration of any family arrangement has to be determined by inferring the intention of parties by perusing such written family arrangement, keeping in view the provision of Section 17(1)(b) of Indian Registration Act. Section 17(1)(b) of Act says that any non-testamentary instrument which purport or operate to create, declare, assign, limit or extinguish any right, title or interest whether vested or contingent, of the value of 100 rupees and upwards to or in a movable property is compulsorily registerable. In Kabul Singh vs. Board of Revenue Air 1973 All. 158 it was observed, broadly speaking, a document called family arrangement as such is not immune from registration, but it will be a question of fact to be determined in each case primarily on the interpretation of the document and the surrounding circumstances, whether the document in question itself creates title or it only acknowledges antecedent title to the property. In Teghh Bahadur Bhujal vs. Debbie Singh Bhujal Air 1966 South Carolina 292 it was observed that where a document is nothing but memorandum of what had taken place and therefore is not a document which would require compulsory registration under Section 17 of the Registration Act. In Kale and Other vs. Director of Consolidation and Others, Air 1976 South Carolina 807, Supreme Court observed, family arrangement may be oral, in which case no registration is necessary. Registration is necessary only if terms of family arrangement are reduced into writing. Here also a distinction should be made under a document containing terms and recitals of family arrangement and mere memorandum prepared after the family arrangement has already been made. In such case memorandum does not require any registration as it by itself does not create or extinguish any right in a movable property. Q. 8. What do you understand by the expressions create, declare, assign, limit, or extinguish, used in Section 17(1)(b) of the Registration Act 1908? Explain with help of decided cases. Ans. Clause B of subsection 1 of Section 17 of Indian Registration Act provides, all non-testamentary instruments which purport or operate to create, declare, assign, limit or extinguish, whether in present or in future, any right, title or interest, whether vested or contingent, of the value of 100 rupees and upwards to or in immovable property, are compulsorily registerable. In Sakha Ram Krishnji vs Madan Krishnji ILR 5 Bone 232, it was observed that an instrument to come within section 17, 1, b, of Registration Act must in itself purport to create, declare, assign, limit or extinguish some right, title or interest of the value of 100 rupees or upwards in immovable property. Create. The word create means to bring into being, to invest with a new title. Therefore every non-testamentary instrument which means to or has the effect of originating some right, title or interest in immovable property will be governed by word "create". Declare. Word "declare" has been dealt with in the context of section 17 in Sukharam Kishanji's case, Supra, and it was observed, term "declare" is placed along with "create". "Limit" or "extinguish" a right, title or interest, and these words imply a definite change of legal relation to the property by an expression of will embodied in the document. Declaration implies a declaration of will and not a mere statement of the facts. So the distinction is between mere recital of a fact and something which in itself create a title. So word declare is equivalent to define, or authoritatively set forth, a new title. Assign. Every non-testamentary instrument which purports or operates to assign any right, title or interest in immovable property of the aforesaid value requires registration. Where under a prior registered gift deed relating to land to be used for holding a market, the donee had the right to make constructions and to earn the income from stallkeepers. But by a subsequent deed the parties agreed that the donor and his heirs should share the income from the stall. It was held that the transaction amounted to a transfer of an interest in the immovable property within the meaning of section 17, 1, b, and the deed required compulsory registration. Limit. A non-testamentary document may limit or restrict some right or interest in immovable property of the said value, and if it does, it must be registered. Thus, the right to hold market in one's land is an incident to the ownership of land. An agreement allocating particular days for holding the bazaar coupled with the condition that the parties are not to be allowed to hold the bazaar on certain other days limits the general right possessed by the owner of the land to hold the market on his lands whenever he wishes to do so. Requires registration. Ganesh Singh vs Sitla Baksh Singh, Air 1931 Auth 110. Extinguished. A right or interest may be extinguished by some divestive fact, as by surrender, relinquishment or release. MST. Sindhi vs MST. Pratapa, Air 1949 EP 207. But a mere abandonment does not extinguish a right or interest. Trilochan Gasutia vs Lochman Pradhan, 14 CPLR 29. Q. 9. Whether a lease deed giving option to tenant to continue so long as he pays monthly rent requires to be registered. Ans. Section 17, 1, d, of the Indian Registration Act lays down that lease of a movable property from year to year or for any term exceeding 1 year or reserving yearly rent can be created only by registered instrument. Section 107 of the Transfer of Property Act lays down that a lease of a movable property from year to year, or for any term exceeding 1 year, or reserving yearly rent, can be made only by a registered instrument. All other leases of a movable property may be made either by a registered instrument or by oral agreement accompanied by delivery of possession. In Muhammad Ismail Khan vs. Jawaharlal Air 1935 All. 492 it was observed, the term of a lease for the purpose of registration must be understood to mean the period for which the lessee is protected against dispossession at the will and pleasure of his lessor, or, in other words, the length of time for which the lessee is entitled to continue in possession provided he himself fulfills all the stipulated conditions. In Kishore Chand vs. Dharmpal Air 1968 PNH 385 it was held that when lessor transfers to lessee rights in demised premises indefinitely subject only to latter continuing to pay the rent. This means that lease was for a term exceeding 1 year. On this conclusion it required registration in view of Section 17, 1, d, of Act. In view of above discussion, in the case in hand lease deed giving option to tenant to continue so long as he pays monthly rent shall be a lease for period exceeding 1 year and thus compulsorily registrable. Q. 10. A lease for 1 year containing an option to the tenant to renew for further period of 1 year. Is such lease compulsorily registerable? Explain by giving reasons. Ans. Section 17, 1, d, of Indian Registration Act provides that a lease of a movable property from year to year or for a term exceeding 1 year or reserving yearly rent. Such deed is compulsorily registerable. In Muhammad Ismail Khan vs. Jawaharlal Air 1935 All. 492 it was observed, the term of a lease for the purpose of registration must be understood to mean the period for which the lessee is protected against dispossession at the will and pleasure of his lessor, or in other words, the length of time for which the lessee is entitled to continue in possession provided he himself fulfills all the stipulated conditions. Therefore, a lease of 1 year containing option to tenant to renew for further period of 1 year or any other term is not a lease for term exceeding 1 year within the meaning of Section 17, 1, d, of the Act, and thus does not require registration. Q. 11. The only question for determination is as to if the lease required registration under Section 17 of Indian Registration Act or not. A had granted lease to be on following terms. Today 1st January 1980, I have given shop on rent to be at rental of Rs 340 per month. Rent shall not be raised or lowered nor shall I eject him. But in case of refusal to pay rent, I shall have right to turn him out. Decide. Ans. Section 17, 1, d, of Indian Registration Act provides that lease deed of any immovable property from year to year or any term exceeding 1 year or reserving yearly rent is compulsorily registerable. A similar provision has been made in Section 107 of Transfer of Property Act. In Ramavdar vs Shanta Bala Air 1954 Cul. 207 it was observed that the term of a lease for the purpose of registration must be understood to mean the period for which the lessee is protected against dispossession at the will and pleasure of his lessor, or in other words, the length of time for which the lessee is entitled to continue in possession, provided he himself fulfills all the stipulated conditions. In the case in hand, A has granted the shop on lease to B with the condition that monthly rent of 340 rupees shall neither be raised nor lowered nor A shall eject B. But if B refuses to pay rent, then only A shall have right to turn B out. So B can hold the possession of leased shop as long as he keep on paying monthly stipulated rent to A. In Kareem Baksh vs Natha Singh 1921, 3 Lahore LJ 14, it was held that where the terms of lease are that there can be no variation in the rent and the landlord is not entitled to eject if rent is paid, but terms of lease do not specify the period for which property is leased out. If the term of lease can be extended at the option of tenant, the lease is not limited to 1 year and requires registration. See also Ganpat Balaji vs Kastur Chand Prem Chand Javeri Air 1945 Nag. 102. So in the case in hand, tenancy is one for a period exceeding 1 year and the lease must be registered. Q. 12 where the following types of leases of a movable property requires registration. Give reasons. A lease for year to year. B. A lease for 6 months. C. A lease for term exceeding 1 year. D. A lease which is for 1 year contains an option to tenant to renew for further period of 1 year. Ans. Section 17, 1, D, of Indian Registration Act provides that lease of a movable property from year to year or for term exceeding 1 year or reserving a yearly rent, require compulsory registration. Section 18, C, of Registration Act provides that lease of a movable property for any term not exceeding 1 year or leases exempted under Section 17 are registerable at the option of parties. Reading together both the provisions, it is evident that lease deed for 1 year or less than 1 year does not require compulsory registration, but if term of lease is exceeding 1 year then it certainly requires compulsory registration. In Muhammad Ismail Khan vs Jawahar Lal, Air 1935 All. 492 it was observed. Term of a lease for the purpose of registration must be understood to mean the period for which the lessee is protected against dispossession at the will and pleasure of his lessor, or in other words, the length of time for which the lessee is entitled to continue in possession provided he himself fulfills all the stipulated conditions. Keeping in view the above said principle, let us see which lease is compulsorily registerable and which is not. A lease for year to year means the lease which can be determined at the end of first or any subsequent year of tenancy, but not in between it. This is a tenancy which does not come to an end by the efflux of time for the simple reason that the time is not limited by the original lease itself. It commences with the year and without any further action on the part of either of the lessor or lessee continues till either party determines it by giving proper notice at the end of any year of tenancy. A tenant from year to year has an interest for 1 year certain, with a growing interest during every year thereafter. Springing out of the original contract and as parcel of it, and such lease is compulsorily registerable in view of Section 17(1)(d) of Act. B. Lease for period of 6 months is not a lease exceeding 1 year, therefore is not compulsorily registerable. C. Lease for term exceeding 1 year is certainly compulsorily registerable in view of Section 17(1)(d) of Indian Registration Act. D. Lease for 1 year containing option to the tenant to renew for further period of 1 year or any other term is not a lease for term exceeding 1 year and therefore does not require compulsory registration under Section 17(1)(d) of the Act. Q. 13. A document is executed by the donor who makes a gift of a movable property and the deed is delivered to donee. The donee accepts the gift but the document is not registered. Will the gift be valid without registration? Ans. Section 17 of Registration Act, 1908 by its clause a provides that an instrument of gift of a movable property requires compulsory registration irrespective of the value of such property. Section 123 of the Transfer of Property Act also provides that a gift of a movable property must be effected by a registered document signed by or on behalf of the donor and attested by at least 2 witnesses. But it does not apply to a gift under any rule of Mohammedan law. When the instrument of gift has been handed by the donor to the donee and accepted by him, the former has done everything in his power to complete the donation and to make it effective. Registration does not depend upon donor's consent, but it is the act of the officer appointed by law for the purpose, who, if the deed is executed by or on behalf of the donor and is attested by at least 2 witnesses, must register it. If it is presented by a person having the necessary interest within the prescribed period, neither death, nor the express revocation by the donor, is a ground for refusing registration, if the other conditions are complied with. Under Muslim law, the gift of the immovable property is complete by delivery of such possession to the donee as the property is susceptible of. In present case, the gift will be effective in law only on the registration of the gift deed. Q. 14. How should the registering officer proceed where document presented for registration A. is written in language which the registering officer does not understand and which is not commonly used in the district. B. contains interlineations, blanks, erasures or alterations. Ans. 14. A. Section 19 of Indian Registration Act provides, if any document duly presented for registration be in a language which the registering officer does not understand, and which is not commonly used in the district, he shall refuse to register the document, unless it be accompanied by a true translation into a language commonly used in the district and also by a true copy. So if any document duly presented for registration be in a language which the registering officer does not understand, and which is not commonly used in the district, he shall refuse to register the document, unless it be accompanied by a true transaction into a language commonly used in district and also by a true copy. Section 19. B. Section 20 of Indian Registration Act deals with the situation when document presented for registration contains interlineations, blanks, erasures or alterations. It says, the registering officer may in his discretion refuse to accept for registration any document in which any interlineation, blank, erasure or alteration appears, unless the persons executing the document attest with their signatures or initials such interlineation, blank, erasure or alteration. If the registering officer registers any such document, he shall, at the time of registering the same, make a note in the register of such interlineation, blank, ensure or alteration. Q. 15. What descriptions of property should be given into a document presented for registration? What is the effect if it is not so described? Ans. Section 21 of Indian Registration Act requires that documents relating to a movable property presented for registration should contain description. Section 21 of Act says, 1. No non-testamentary document relating to a movable property shall be accepted for registration unless it contains a description of such property sufficient to identify the same. 2. Houses in towns shall be described as situate on the north or other side of the street or road, which should be specified, to which they front, and by their existing and former occupancies, and by their numbers if the houses in such street or road are numbered. 3. Other houses and lands shall be described by their name, if any, and as being in the territorial division in which they are situate, and by their superficial contents. The roads and other properties on which they stand and their existing occupancies, and also, whenever it is practicable, by reference to a government map or survey. 4. No non-testamentary document containing a map or plan of any property comprised therein shall be accepted for registration unless it is accompanied by a true copy of the map or plan, or, in case such property is situate in several districts, by such number of true copies of the map or plan as are equal to the number of such districts. So, Section 21 provides for two requirements. 1. That the instrument shall contain a description of the property sufficient to identify it, and 2. That, if the instrument contains a map, a copy or copies of the map shall accompany the instrument when presented for registration. Section 21 should be read with Section 22 of the Act, which says, 1. Where it is, in the opinion of the state government, practicable to describe houses, not being houses in towns, and lands by reference to a government map or survey, the state government may, by rule made under this Act, require that such houses and lands as aforesaid shall, for the purposes of Section 21, be so described. 2. Save as otherwise provided by any rule made under subsection 1, failure to comply with the provisions of Section 21, subsection 2, or subsection 3. Shall not disentitle a document to be registered if the description of the property to which it relates is sufficient to identify that property. Q. 16. What is the time limit for presenting a document for registration? Ans. Part 4 of Indian Registration Act containing sections 23 to 27 provides as to time within which a document may be presented for registration. Section 23 of the Act gives general rule by providing, subject to the provisions contained in Section 24, 25 and 26, no document other than a will shall be accepted for registration unless presented for that purpose to the proper officer within 4 months from the date of its execution, provided that a copy of a decree or order may be presented within 4 months from the day on which the decree or order was made, or where it is appealable within 4 months from the day on which it becomes final. In Ram Singh Sant Ram vs Jasmeer Singh Vardit Singh Air 1963 Punj 100 it was observed that, according to Section 23 of the Act, no document other than a will can be accepted for registration unless presented for that purpose to the proper officer within 4 months from the date of its execution. Under Section 25 of the Act, a further period of 4 months is allowed for registration in certain cases of urgent necessity or unavoidable accident. That is to say, 8 months is the outside limit for presenting the document of registration. Section 24 provides that, where there are several persons executing a document at different times, such document may be presented for registration and re-registration within 4 months from the date of each execution. Section 25 lays down as follows. 1. If, owing to urgent necessity or unavoidable accident, any document executed, or copy of a decree or order made in India is not presented for registration till after expiration of the time herein before prescribed in that behalf, the Registrar, in cases where delay in presentation does not exceed 4 months, may direct that, on payment of a fine not exceeding 10 times the amount of the proper registration fee, such document shall be accepted for registration. 2. Any application for such direction may be lodged with a Sub-Registrar, who shall forthwith forward it to the registrar to whom he is subordinate. Section 26 of the Act then provides, when a document purporting to have been executed by all or any of the parties out of India is not presented for registration till after the expiration of the time herein before prescribed in that behalf, the registering officer is satisfied a. that the document was executed, and b. that it has been presented for registration within 4 months after arrival in India, may on payment of proper registration fee, accept such document for registration. Section 27 of the Act says a will may at any time be presented for registration or deposited in the manner as provided in Parts 8 and IX of the Act. Q. 17. In what circumstances, the registrar can proceed to the re-registration of a document. Ans. Section 23A of Indian Registration Act provide for re-registration of certain documents. Section 23A was added to Indian Registration Act with a Amendment Act of 1917 as it became necessary in view of pronouncement of Privy Council in Jambu Prasad vs. Mohammed Aftab Ali Khan Air 1914 PC 16, wherein it was held that when a document is presented for registration by an agent who is not authorized by a power of attorney in accordance with Section 33 of the Act, the registering officer has no jurisdiction to register the document nor to endorse thereon a certificate under Section 60, and such registration is invalid. Section 23A of Act lays down as under. Notwithstanding anything to the contrary contained in the Act, if, in any case, a document requiring registration has been accepted for registration by a registrar or sub-registrar from any person not duly empowered to present the same and has been registered, any person claiming under such document may within 4 months from his first becoming aware that the registration of such document is invalid, present such document or cause the same to be presented. In accordance with the provisions of Part 6 for registration in the office of the Registrar of the district in which the document was originally registered, and upon the Registrar being satisfied that the document was so accepted for registration from any person not duly empowered to present the same, he shall proceed to re-registration of the document as if it had not been previously registered, and as if such presentation for re-registration was a presentation for registration made within the time allowed therefor under Part 4, and all the provisions of this Act as to registration of documents, shall apply to such registration, and such documents if duly re-registered in accordance with the provisions of this section, shall be deemed to have been duly registered for all purposes from the date of its original registration, provided that, within 3 months from the 12th day of September, 1917, any person claiming under the document to which this section applies may present the same, or cause the same to be presented for re-registration in accordance with this section whatever may have been the time when he first became aware that the registration of the document was invalid. Q. 18 When the document executed by several persons at different time may be presented for registration. Uns. Section 24 of Indian Registration Act provides, where there are several persons executing a document at different times, such document may be presented for registration and re-registration within 4 months from the date of each execution. Section 24 should be read with Section 34, 2. Section 24 deals with partial registration, i.e., partial as to the persons executing it. Where a document which has been executed by several persons and it is registered upon the appearance and admission of some of the executants, there is no effective registration as regards other executants who neither appear nor admit execution. In Air 1928 Nag. 239 it was observed that when a document is executed by several persons at different times, the Section 24 of the Act contemplates registration within 4 months of the last execution of all previous executions whether they were within 4 months or not. Q. 19 A lease deed is signed and executed on the 4th of July 1989. It is presented for registration on the 6th of November 1989. Can it be registered? Ans. Section 23 of the Indian Registration Act provides that no document other than a will shall be accepted for registration unless presented within 4 months from the date of its execution. In computing the period of 4 months, the day on which the document is executed should be excluded. So ordinarily all the documents other than will must be presented for registration within 4 months from the date of execution. Section 25 of the Act provides that if, owing to urgent necessity or unavoidable accident, any document executed or copy of a decree or order made is not presented for registration till after the expiration of the time herein before prescribed in this behalf, the Registrar, in cases where the delay in presentation does not exceed 4 months, may direct that, on payment of a fine not exceeding 10 times the amount of the proper registration fee, such document shall be accepted for registration. In the present case, the document was signed and executed on 4.7.1989. The same could have been presented for registration within 4 months thereof, i.e. on or before 4.11.1989. But the document has been presented on the 6th of November 1989, i.e. after 2 days of the expiry of the period prescribed. Under Section 25, the Registrar has the power to condone the delay if some urgent necessity or unavoidable accident is shown, and he can direct, on payment of the fine not exceeding 10 times the amount of the proper registration fee, such document shall be accepted for registration. Q. 20A document was executed out of India and it has been presented for registration within 3 months and 15 days after its arrival in India. Can the registering officer accept the document for its registration in India? Ans. Section 23 of the Indian Registration Act provides that no document other than a will shall be accepted for registration unless presented within 4 months from the date of his execution. In computing the period of 4 months, the day on which the document is executed should be excluded. Section 26 of the Act makes a provision for registration of documents executed out of India, and lays down that if such document has been presented for registration till after the expiration of the prescribed time, the document may be received for registration if it is shown that the document has been presented for registration within 4 months after its arrival in India. In the present case, the document was executed outside India. It was presented for registration within 3 months and 15 days of its arrival in India, i.e. within the period of 4 months as allowed by law. The document can be accepted for registration. Q. 21 state the provisions relating to place of registering the documents as given in the Indian Registration Act. Ans. Part 5 of Indian Registration Act containing sections 28 to 31 deals with place of registration of document. Section 28 of the Act provides for the place for registering documents relating to land and Section 29 provides for the place for registering other documents. These provisions are discussed below. Section 28 of the Act says, save as in this part otherwise provided, every document mentioned in Section 17 subsection 1, clauses A, B, C, D, and A, Section 17, subsection 2. Insofar as such document affects a movable property and Section 18 clauses A, B, C, and CC shall be presented for registration in the office of a sub-registrar within whose sub-district the whole or some portion of property to which such documents relates is situate. In Julumdhari vs. Debi Raj Air 1965 Patna 279, it was held that as long as the law permits registration of a document at a place where any portion of the land covered by any deed of transfer is situate, parties can take advantage of that and get the document registered at a place where not the bulk of the land under transfer but only a small portion which was also intended to be transferred is situate. Section 29(1) of the Act then says, every document not being document referred to in Section 28, or a copy of a decree or order, may be presented for registration either in the office of the sub-registrar in whose sub-district the document was executed, or in the office of any other sub-registrar under the state government at which all the persons claiming under the decree or order desire the same to be registered. Subsection 2 to Section 29 of the Act says, a copy of decree or order may be presented for registration in the office of the sub-registrar in whose sub-district the original decree or order was made or where the decree or order does not affect the immovable property. In the office of any other sub-registrar under the state government at which all the persons claiming under the decree or order desire the copy to be registered. Section 30 of the Act provides as under 1. Any registrar may in his discretion receive and register any document which might be registered by any sub-registrar subordinate to him. 2. The registrar of a district in which a presidency town is included and the registrar of the Delhi district may receive and register any document referred to in Section 28 without regard to the situation in any part of India of property which the document relates. Section 31 of the Act lays down, in ordinary cases the registration or deposit of documents under this Act shall be made only at the office of the officer authorized to accept the same for registration and deposit, provided that such officer may on special cause being shown attend at the residence of any person desiring to present a document for registration or to deposit a will, and accept for registration or deposit such document or will. Q. 22 Can a document be presented at the private residence for registration? Ans. Section 31 of Indian Registration Act is relevant. It provides us, in ordinary cases the registration or deposit of documents under this Act shall be made only at the office of the officer authorized to accept the same for registration or deposit, provided that such officer may on special cause being shown attend at the residence of any person desiring to present a document for registration or to deposit a will, and accept for registration or deposit such document or will. So, in extraordinary cases registration can be validly done at places other than the office of the registering officer or the residence of the person desiring to present the document for registration. The words, "may on special cause being shown," in proviso to Section 31 imply that the registering officer is the judge of the sufficiency of the special cause, and, if he is satisfied, the court has no power to question his decision on that point. Assuming that the discretion was not rightly exercised by him, it was a mere defect of procedure within the meaning of Section 87. Q. 23. Who can present the document for registration? Ans. Section 32 of Indian Registration Act provides that every document to be registered compulsorily or optionally shall be presented at proper registration office. A. By some person executing the document or claiming under the document, or, in the case decree or order, claiming under the decree or order, or B. By the representative or assign of such person, or C. By the agent of such person, representative or assign, duly authorized by power of attorney executed and authenticated in the prescribed manner. Section 32. The object of the legislature in enacting Section 32 is to prevent a mere outsider from presenting for registration a document with which he has no concern. To allow all and sundry to present document for registration would be to open a door of fraud and forgery. Therefore intended to provide that registration should be initiated by the document being presented for registration by person having direct relation to deed. In Shri Kishore Chandra Singh Dio vs. Babu Ganesh PD. Bhagat Air 1954 South Carolina 316, Supreme Court observed. One object of Sections 32 to 35 is to make it difficult for persons to commit fraud by means of registration under the Act. And it is the duty of the courts in India not to allow the imperative provisions of the Act to be defeated when it is proved that an agent who presented a document for registration had not been duly authorized in the manner prescribed by the Act to present it. Section 33, 1, of the Indian Registration Act provides that for the purposes of Section 32 of the Act, the following powers of attorney are alone recognized. A power of attorney executed before and authenticated by the registrar or sub-registrar within whose district or sub-district the principal resides. If the principal at the time of executing the power of attorney resides in any part of states in which the Indian Registration Act is in force. B. A power of attorney executed before and authenticated by a magistrate if the principal at the time of executing the power of attorney resides in any other part of the state in which the said act is not in force. C. A power of attorney executed before and authenticated by a notary public, any court, judge, magistrate, Indian consul, vice consul or representative of the central government. If the principal at the time of aforesaid does not reside in India. Provided that the following persons shall not be required to attend at any registration office or court for the purpose of executing any such power of attorney as is mentioned in clauses A and B of this section, namely, I. Persons who by reason of bodily infirmity are unable without risk of serious inconvenience so to attend. E. Persons who are in jail under civil or criminal process, and E. Persons exempt by law from personal appearance in court. 2. In the case of every such person the registrar or sub-registrar or magistrate, as the case may be. If satisfied that the power of attorney has been voluntarily executed by the person purporting to be principal, may attest the same without requiring his personal attendance at the office or court aforesaid. 3. To obtain evidence as to the voluntary nature of the execution, the registrar or sub-registrar or magistrate may either himself go in the house of the person purporting to be the principal, or to the jail in which he is confined, and examine him, or issue a commission for his examination. 4. Any power of attorney mentioned in this section may be proved by the production of it without further proof when it purports on the face of it to have been executed before and authenticated by the person or court herein before mentioned in that behalf. Q. 24. Should a registering officer make any inquiry before registering a document? Discuss in brief the procedure to be adopted by registering officers for registration of documents as provided under the Registration Act. Ans. Section 34 of Indian Registration Act provides for inquiry to be made by registering officer before registration of any document. Section 34(1) of the Act lays down, subject to the provisions contained in this part and in sections 41, 43, 45, 69, 75, 88 and 89, no document shall be registered under this Act, unless the persons executing such document, or their representatives, assigns or agents authorized as aforesaid appear before the registering officer within the time allowed for presentation under sections 23, 24, 25 and 26. Provided that, if owing to urgent necessity or unavoidable accident all such persons do not so appear, the registrar in cases where delay in appearing does not exceed 4 months, may direct that on payment of fine not exceeding 10 times the amount of the proper registration fee, in addition to the fine, if any, payable under section 25, the document may be registered. Subsection 4 of section 34 says any application for direction under the proviso to subsection 1 may be lodged with sub-registrar, who shall forthwith forward it to the registrar to whom he is subordinate. Section 34(2) says that appearances provided in subsection 1 may be simultaneous or at different times. Section 34(3) then says, the registering officer shall thereupon a. Enquire whether or not such document was executed by the persons by whom it purports to have been executed. b. Satisfy himself as to the identity of the persons appearing before him and alleging that they have executed the document, and c. In the case of any person appearing as a representative, assign or agent, satisfy himself of the right of such persons so to appear. The provisions of this section do not apply to copies of decree or orders. Section 34(5). In Ajit Investment Company vs. G. Malwadkar Air 1973 Boom. 285 it was observed that Section 34 has inter alia provided that no document shall be registered unless the person executing such documents, or their representatives, assigns or agents appear before the registering officer within the time allowed for presentation. Such appearance may be simultaneous or at different times. Subsection 3 of Section 34 thereof provides that the registering officer shall thereupon inquire whether or not such document was executed by the persons by whom it purports to have been executed. b. Satisfy himself as to the identity of the persons appearing before him and alleging that they have executed the document, and c. In the case of any person appearing as a representative, assign or agent, satisfy himself of the right of such persons so to appear. Section 35 of the Registration Act provide procedure on admission and denial of execution of document. Section 35, 1, says, a. If all the persons executing the document appear personally before the registering officer and are personally known to him, or if he be otherwise satisfied that they are the persons they represent themselves to be, and if they all admit the execution of the document. Or b. If in the case of any person appearing by a representative, assign or agent, such representative, assign, or agent admits the execution. c. If the person executing the document is dead, and his representative or assign appears before the registering officer and admits the execution. d. The registering officer shall register the document as directed in sections 58 to 61 inclusive. Section 35, 2, of the Act provides, the registering officer may, in order to satisfy himself that the persons appearing before him are the persons they represent themselves to be, or for any other purpose contemplated by this Act, examine anyone present in his office. Subsection 3 to Section 35 then provides, if any person by whom the document purports to be executed denies its execution, or b. If any such person appears to the registering officer to be a minor, an idiot or a lunatic, or c. If any person by whom the document purports to be executed is dead, and his representative or assign denies its execution, the registering officer shall refuse to register the document as to the person so denying, appearing or dead, provided that, where such officer is a registrar, he shall follow the procedure prescribed in Part 12. Provided further that the state government may, by notification in the Official Gazette, declare that any sub-registrar named in the notification shall in respect of documents, the execution of which is denied, be deemed to be a registrar for the purposes of this subsection and of Part 12. In Ajit Investment Company vs. G. Malwadkar, Supra, it was observed by Kantawala, J. of the High Court of Bombay that there is enough indication in the provisions of the Registration Act, 1908, to suggest that it is impossible for the registering officer to register a document qua some of the executants, though it may not be registered qua the rest. If regard be had to the provisions of Section 35, 3, of the Registration Act, it is amply clear that the legislature never intended refusal to register a document in toto simply because some of the executants thereto may not produce the tax clearance certificate as provided by Section 34 of the Wealth Tax Act or Section 230A of the Income Tax Act. Under Section 35, 3, when execution of a document is denied by some or when the party executing it appears to be a minor, an idiot or a lunatic. Or in case of an executant who is dead and his representative or assign denies the execution, the registering officer has to refuse to register the document as to the person so denying. Appearing or dead. Section 36 of Act then provides, if any person presenting any document for registration or claiming under any document which is capable of being so presented desires the appearance of any person whose presence or testimony is necessary for the registration of such document, the registering officer may, in his discretion, call upon such officer or court as the state government directs in this behalf to issue summons requiring him to appear at the registration office either in person or by duly authorized agent at time mentioned in the summons. Section 37 says, the officer or court upon receipt of the process fee payable in such cases shall issue the summons accordingly and cause it to be served upon the person whose appearance is so required. Under Section 38 of the Indian Registration Act, the following persons are not required to appear at the registration office. I. Persons who by reasons of bodily infirmity are unable without risk or serious inconvenience to appear at the registration office. E. Persons in jail under civil or criminal process, or E. Persons exempted by law from personal appearance in court. Section 38, 2. Says in case of every such person the registering officer shall either himself go to the house of such person or to the jail in which he is confined and examine him or issue commission for his examination. Section 39 of the Act makes it clear that the law in force as to summons, commissions and compelling the attendance of witnesses and the law for their renunciation in suits before civil courts applies to any summons or commission issued and any person summoned to appear under the Indian Registration Act. Q. 25 discuss the provisions of Indian Registration Act 1908 regarding presenting and deposit of backward wills for registration. Uns. Sections 40 and 41 of Indian Registration Act provide as to registration of wills. Section 40, 1, lays down, testator or after his death any person claiming as executor or otherwise under a will, may present it to any registrar or sub-registrar for registration. In Gurudat Singh vs. Durga Devi, Air 1966 J&K 75, it was observed that a will may be presented at any time before any registering officer. When a will is presented for registration by representatives of testator, the procedure prescribed by Section 35 does not apply. No inquiry need be made as to minority or sanity of the testator. But it is also well established that if a will is registered by testator, this will be a strong circumstance to support the genuineness of the will, but the same cannot be said of a will which is registered after his death or without his knowledge. Section 41 of the Act then provides, 1. A will or an authority to adopt presented for registration by the testator or donor may be registered in the same manner as any other document. 2. A backward will, or backward authority to adopt, presented for registration by any other person entitled to present it shall be registered if the registering officer is satisfied, I. that will, or authority to adopt, was executed by testator or donor, e. that testator or donor is dead, e. that the person presenting the will, or authority to adopt, is entitled to present it. So the effect of sections 40 and 41 of the Act is that a will and an authority to adopt can be presented for registration after the death of the testator and the donor of the authority. These sections do not exclude the operation of Section 32 of Act. Rules as to deposit of wills. The rules as to deposit of wills have been provided under Sections 42 to 46 of the Indian Registration Act. These are given below. Section 42 of the Act provides, any testator may either personally or by duly authorized agent deposit with any registrar his will in a sealed cover superscribed with the name of the testator and that of his agent, if any, and with a statement of the nature of the document. Section 43 of the Act lays down, on receiving such cover, if the registrar is satisfied that the person presenting the same for deposit is the testator or his agent, the registrar shall transcribe in his registrar book number 5 the superscription above said and shall note in the same book and on the said cover the month, day, hour of such presentation and receipt, the names of any persons who may testify the identity of the testator or his agent and any legible inscription which may be on the seal of the cover. The registrar shall then place and retain the sealed cover in his fireproof box. Section 44 says that, if the testator who has deposited such cover wishes to withdraw it, he may apply, either personally or by duly authorized agent, to the registrar who holds it in deposit. If and the registrar is satisfied that the applicant is actually the testator or his agent, the registrar shall deliver the cover accordingly. Section 45 of the Act says, if on the death of a testator who has deposited a sealed cover, an application is made to the registrar who holds it in deposit to open the same, and if the registrar is satisfied that the testator is dead, the registrar in the presence of the applicant opens the cover and at the applicant's expense causes the contents thereof to be copied into his book number 3. When such copy has been made, the registrar shall redeposit the original will. Section 46, 1, of the Act says, nothing hereinbefore contained shall affect the provisions of Section 259 of the Indian Succession Act, 1865, or Section 81 of the Probate and Administration Act, 1881. Or the power of any court by order or compel the production of any will. Subsection 2 to Section 46 says, when any such order is made, the registrar shall, unless the will has been already copied under Section 45, open the cover and cause the will to be copied into his book number 3 and make a note on such copy that the original has been removed into court in pursuance of the order aforesaid. In C.W. Mariano vs. the R.T., Reverend F. Provost Air 1941 Rang. 305 it was observed. The object and effect of sections 42 to 46 are that the contents of the sealed cover deposited by the testator shall remain secret during his lifetime. But on his death the terms of his will shall be made public and copies of the will shall be available to the public. Q. 26. Determine the validity of two registered documents executed by some person in respect of the same property to two different persons at two different times. Ans. Section 47 of Indian Registration Act provides for the time from which a registered document operates. It lays down as under: a registered document shall operate from time from which it would have commenced to operate if no registration thereof had been required or made, and not from the time of its registration. So, Section 47 does not purport to create a new title but only affirms the title which was created by the deed. The title is complete when the deed is executed, and the effect of registration is only to make it absolute and unquestionable. So according to Section 47 of the Act, priority is determined as to date of execution and not according to date of registration, and as soon as a document is registered, it relates back and becomes operative from the date of execution. As between two registered documents, the date of execution determines the priority of two registered deeds executed by same person in respect of the same property to two different persons at two different times. The one which is executed first has under Section 47 priority over the other, although the former deed is registered subsequently to the latter. If a deed is tendered for registration within the time allowed by the Act and duly registered, it is immaterial that another deed has priority of registration. Q. 27. Explain the effects of registration under the Act. Ans. Effects of registration. Section 48 of Indian Registration Act provides: all non-testamentary documents duly registered under this Act and relating to any property, whether movable or immovable, shall take effect against any oral agreement or declaration relating to such property unless the agreement or declaration has been accompanied or followed by delivery of possession, and the same constitutes a valid transfer under law for the time being in force, provided that a mortgage by deposit of title deeds as defined in Section 58 of the Transfer of Property Act shall take effect against any mortgage deeds subsequently executed and registered which relates to the same property. So under Section 48 of the Act, a registered instrument is to have priority over an oral agreement unless the agreement or declaration has been accompanied or followed by delivery of possession. The object of Section 48 of the Act is to limit the operation of oral alienations. In Ghasi Ram vs Shankar Lal, Ayer 1960 MP3, while following the decision of Vaman Ramchandra vs D. Krishnji ILR 4 Bom. 126, it was observed. Section 48 of the Indian Registration Act, 8 of 1871, provides that a document, duly registered under that Act, shall take effect against an oral agreement unaccompanied by possession. But that provision cannot properly be applied to a registered document which has been given, accepted and registered in favor of a third party, as is the case with the registered deed of sale which has been given by the first defendant, and accepted by the other defendants, with full notice of the prior contract of sale to the plaintiff by the first defendant. The object of that section was to prevent fraud. The application of it in favor of the second, third and fourth defendants would be to render fraud triumphant. Section 48 of Act refers to the priority of registered document over oral agreements, and Section 50 of the Act refers to priority of registered document over non-registered written document. Section 50 reads as under. Every document of the kinds mentioned in clauses A, B, C, and D of Section 17, subsection 1, and clauses A and B of Section 18, shall, if duly registered, take effect as regards the property comprised therein, against every unregistered document relating to the same property and not being a decree or order, whether such unregistered document be of the same nature as the registered document or not. Q. 28 A. Deposits the title deeds of his property with B to secure payment of a loan made to him by B. A then executes a legal mortgage of same property to C. The mortgage deed to C is duly registered. Is C entitled to priority over B? Decide. Uns. Section 48 of the Registration Act lays down that all non-testamentary documents duly registered and relating to any property, whether movable or immovable, shall take effect against any oral agreement or declaration relating to such property, unless where a. The agreement or declaration has been accompanied or followed by delivery of possession, and b. The same constitutes a valid transfer under any law for the time being in force. But, however, a mortgage by deposit of title deed as defined in Section 58 of the Transfer of Property Act, 1882, shall take effect against any mortgage deed subsequently executed and registered which relates to the same property. So under the proviso to Section 48 of the Registration Act, equitable mortgage takes effect against any mortgage deed relating to the same property if executed and registered subsequent to the equitable mortgage. In the present case, mortgage in favor of B is equitable mortgage which is prior in time. As such, it will have priority over the subsequent mortgage made in favor of C, through a registered deed, and B must consequently succeed. Q. 29 discuss the effects of non-registration of documents under Indian Registration Act. Refer to cases. Uns. Section 49 of the Registration Act provided as follows. No document required by Section 17 or by any provision of the Transfer of Property Act, 1882, to be registered shall a. Affect any immovable property comprised therein, or b. Confer any power to adopt, or c. Be received as evidence of any transaction affecting such property or conferring such power, unless it has been registered. Provided that an unregistered document affecting a movable property and required by this Act or the Transfer of Property Act, 1882 to be registered may be received as evidence of a contract in a suit for specific performance under Chapter 2 of the Specific Relief Act, 1877, or as evidence of part performance of a contract for the purposes of Section 53A of the Transfer of Property Act, 1882. Or as evidence of any collateral transaction not required to be effected by registered instrument. So Section 49 of Registration Act consists of two parts. It provides first, that no document required by Section 17 or by provision of Transfer of Property Act to be registered shall affect any immovable property comprised therein. The second part of the section says that a document shall not be received as evidence of any transaction affecting such property. The two parts of section deal with different subjects. The first part presupposes that the document itself is the transaction or the mode in which it is carried out. The second part relates to cases where the document is not the transaction but is only record of transaction. In Narendra Kumar vs. Hansraj Air 1986 HP 75 it was observed, Section 49 of Registration Act does enjoin that no document which requires compulsory registration either under Section 17 of that Act or under any provision of the Transfer of Property Act any immovable property comprised therein or confer any power to adopt or be received as evidence of transaction affecting such property unless it has been registered. At the same time, however, the proviso appended to this section lays down in no ambiguous terms that an unregistered document affecting immovable property and requiring compulsory registration may be received in evidence to prove any collateral transaction not required to be effected by a registered instrument or as evidence of part performance of a contract for the purposes of Section 53A of the Transfer of Property Act. Under the provisions of Section 50, an unregistered document gives way to a subsequent registered deed in respect of the same property. In other words, a subsequent registered deed takes effect against a previous unregistered deed in respect of the same property. To sum up, of the following are the effects of non-registration. 1. The unregistered document shall not affect any immovable property comprised in it. 2. It shall not confer any power to adopt. 3. It shall not be received as evidence of any transaction affecting such property or conferring such power. 4. It gives way to a subsequent registered deed in respect of the same property. That is, it will take effect against a previous unregistered deed in respect of the same property. Q. 30(s) gives her house on lease for 2 years to T. The lease deed is not registered. What will be the effect of non-registration of the lease deed? Ans. Section 17, 1, d, of Indian Registration Act requires that the lease of a movable property from year to year or for any term exceeding 1 year or reserving yearly rent should be compulsorily registered. So lease in the present case was compulsorily registerable, however lease deed has not been registered. Section 49 of Indian Registration Act provides as to effect of non-registration of documents required to be registered. Section 49 lays down, no document required by Section 17 or by any provision of the Transfer of Property Act 1882, to be registered shall a. affect any immovable property comprised therein, or b. confer any power to adopt, or c. be received in evidence of any transaction affecting such property or conferring such power, unless it has been registered. So where a document which is required to be registered in view of provisions of Section 17 of Act, if not registered will not avail to create, declare, assign, limit or extinguish any right, title or interest in or to a movable property comprised in the document, nor will confer any power to adopt, and no such unregistered document can be received in evidence for proving creation, declaration, assignment, limitation or extinction of any right, title or interest to or in a movable property comprised in the document. However, Proviso to Section 49 provides that an unregistered document affecting a movable property which is required to be registered may be received as evidence of contract in a suit for specific performance, or as evidence of part performance of contract, or as evidence of any collateral transaction not required to be effected by registered instrument. So in view of Proviso to Section 49 of Act, an unregistered document may be looked at as evidence of collateral transactions, which are not required to be effected by registered instrument. Therefore, a lease of a movable property which is compulsorily registerable, if not registered, though cannot be received in evidence to prove the transaction affecting a movable property to which it relates, but in view of Proviso to Section 49. Such unregistered lease deed can be received in evidence for proving collateral transactions such as nature of possession over property by lessee, etc. Q. 31. The only point in dispute before the court is whether the premises in dispute had been let out to defendant for residential purposes as contended by the plaintiff, or the same had been taken by in for commercial purposes as contended by the defendant. The parties had admittedly executed an agreement in writing in which the purpose of letting is mentioned. The agreement, though it required registration, has not been registered. The plaintiff has produced the agreement in court for proving his case about the purpose of letting. The defendant has contended that the agreement cannot be admitted into evidence for determining the controversy. How will you decide? Give reasons. Ans. Point in issue involved in the case in hand is whether plaintiff can prove in evidence an unregistered document, which was required to be registered under the law, for the purpose of proving the fact that premises in dispute was let out to defendant for residential purpose. Section 49 of Indian Registration Act provides as to the effect of non-registration of a document which was required by the Act to be registered. Section 49 of Act says that any document which is required under Section 17 of Indian Registration Act or under any provision of Transfer of Property Act to be registered but not registered will I. Not affect any immovable property comprised therein, or e. Not confer any authority to adopt, or e. Not be received in evidence of any transaction affecting such property or conferring such power, provided that an unregistered document affecting the immovable property required to be registered under this Act or Transfer of Property Act may be received in evidence of contract in a suit for specific performance or evidence of part performance of a contract, or as evidence of any collateral transaction not required to be effected by registered document. So Section 49 of the Act implies that any document which is required under the law to be registered, if not registered, will not create or extinguish etc. Any right to or in a movable property comprised in such document nor shall be received in evidence of transaction affecting such a movable property. However, such an unregistered document can be received in evidence of contract in a suit for specific performance or evidence of past performance of contract, or for any collateral transaction which is not required to be effected by a registered document. Coming to the case in hand, an agreement was admittedly executed between plaintiff and defendant in which purpose of letting the property is also mentioned. Although such agreement was required to be registered but not got registered, such unregistered document may not be given in evidence to prove the fact of letting the premises to defendant, but such unregistered document can be received in evidence to prove collateral transactions, and therefore plaintiff can prove such registered document for proving the purpose of letting the premises in view of proviso to Section 49 of the Act. Q. 32. What are the rules governing the priority of registered over an unregistered document? Ans. 32. Section 50 of Indian Registration Act is relevant. Section 50 says that every document of the kinds mentioned in clauses A to D of Section 17, 1, and in CLs A and B of Section 18 shall, if duly registered, take effect as regards the property comprised therein against every unregistered document relating to the same property. Such unregistered document may be of the same nature as the registered document, or they may be different in nature, or they may have been executed by different persons. The provisions of Section 50, 1, contemplate both cases where documents are compulsorily registerable and those where registration is optional. The documents mentioned in various clauses of Section 17, 1, are compulsorily registerable, while those in CLs A and B of Section 18 are optional. In the latter case, the question of priority arises after the documents optionally registerable are registered. Nothing in subsection 1 applies to cases exempted under the proviso to subsection 1 of Section 17 or to any document mentioned in subsection 2 of the same section or to any registered document which had no priority under the law and force at the commencement of this Act. But under the following circumstances, registered documents are not entitled to priority over unregistered ones. 1. Where the unregistered document relating to the same property is a decree or order. 2. In case of unregistered leases which are exempted from compulsory registration under the proviso to subsection 1, Section 17. 3. In case of unregistered documents which are exempted from registration under Section 17, 2. 4. In case where the registered document has no priority under the law in force when the Registration Act came into force. 5. Where the subsequent transferee under the registered document has actual notice of the previous unregistered document of which registration is optional. Q. 33. A Hindu widow owned a house. On the 28th of April 63 she adopted B as her son and executed a deed of adoption. This document, which is not registered, also contains a covenant wherein she has stated that after this deed of adoption her adopted son will be entitled to whole property and she will have no right to alienate any part of property. The widow, A, sold the house to C by registered sale deed. C filed a suit for possession against B on the basis of registered sale deed. B relied upon recital of adoption deed to plead that A had no right to sell the house. Decide. Ans. Section 17, 1, B, of Indian Registration Act clearly provides that such document where any right in a movable property is either created, assigned, declared or limited or extinguished will require registration. Adoption deed in the case in hand operates to create an immovable property of A in favor of B. Therefore that adoption deed was required to be compulsorily registered under Section 17 of the Act, which was not actually registered, so in view of Section 49 of the Act, does not confer any right or title to B, thus deed will not be helpful to B. Moreover, in view of Section 50 of Indian Registration Act, registered sale deed will have to be preferred than an unregistered deed of adoption.